All right, we're going to move on. Our next section is CSI, Claims, Statements, and Investigation. How Missouri, Illinois, and Kansas cases may be affected. Dave Reynolds, Michelle Simek, and David Mosh.
Thanks, Pat. As he just said, this is going to be a little bit of a potpourri of topics regarding claims, statements, and investigation in Illinois, Missouri, and Kansas. And then we will hit the new Temple-Meyer decision here at the end in case anybody's... Are we having trouble?
We have a mic issue.
It's a very tough topic.
Microphone. Nope.
No, here, you want this one? He's coming. Give him a minute. You're behind time.
Technical glitch.
We asked for 15 minutes of technical glitches. Yeah, just use that one. You get to hold it.
Okay. Am I on now? Okay, thank you. Is it just me?
I think he's got to turn it on. Now go.
I got the thumbs up. Here we go. Okay, fantastic. A potpourri of topics. We'll go through some claims, investigation, statements, things that might be helpful to everyday practice, field questions, text questions as we go, and then I will hit the Temple-Meyer case at the end of the presentation. It's a case that came out April 15th. It's a little bit of a new hot topic, so you can stick around for that at the very end. Regarding claims, in Missouri, there's a new claim form due to the occupational disease provisions of SB 1. Mr. Kennedy is going to talk about this here at the top of the next hour. I think he affectionately refers to this as the meso mess. If you've seen any of the new claims coming in for date of injury, January 1, 2014 or later, you'll notice a new box in the center of the claim that it directly addresses toxic exposure occupational diseases by name. The claim form is also different on the back side, where the second injury fund box used to be. There is no space anymore for permanent partial claims against the second injury fund because claims for permanent partial disability will not be allowed as of January 1, 2014. So that portion is gone too, as much as I liked it when attorneys completed that portion, so you kind of knew what kind of priors you might be dealing with. That is no longer in the claim form. Timely answers, whether that's important in Missouri, Illinois, and Kansas. I'll take on Missouri. Answer must be filed timely within 30 days. Otherwise, any factual assertions in that claim for compensation will be deemed admitted. I got to talk about the TH versus Sonic Drive-In case last year where the court decided even a statement of a max rate for the average weekly wage was a factual assertion that could potentially be deemed admitted if a timely answer wasn't filed. So that is consideration. How about in Illinois?
Can everyone hear me? Okay. The first thing I just wanted to mention is the Illinois case law update is on pages 57 to 65 in the booklet. And that was done by Mike Carr and Katie Whitaker, so I appreciate they did a great job on that. But I'll mention a few of these cases, so I wanted to let you know where they were in the booklet. In terms of claims, from Illinois standpoint, there's no, unlike Missouri where you file an answer to the claim for compensation, in Missouri you don't file an answer to the application for adjustment of claim, as it's called in Illinois, but you do enter your appearance, and of course that's very important. You get a application for adjustment of claim in, and you send it to your attorney. In Illinois, the thing I just wanted to mention a couple things about claims in Illinois is they can go to trial much faster in Illinois than Missouri. Missouri, you have some time to react. You get a request for a hardship setting, for instance. The Division of Workers' Compensation in St. Louis will usually set it for hardship mediation and thereafter set it for a hearing. In Illinois, you can go to hearing within 15 days, so you have to be on the lookout for an application for adjustment of claim and a 19B petition for hearing. I guess the other thing I would mention is on the claim, the application for adjustment of claim, you probably want to look at what's being alleged on the for body parts, and I would also suggest looking at what the average weekly wage, the AWW, shows. That is an issue numerous times in Illinois work comp litigation. Unlike Missouri, where you only need the 13 weeks preceding the date of accident, in Illinois you need the 52 weeks preceding the date of accident. And if you can break it down, not to ask, ask a little bit more of you, but if you can break it down to exclude the overtime, that we can get to what the average weekly wage is. In Illinois, overtime is not supposed to be included unless it's mandatory and consistent. But those are some of the things I would look at in terms of Illinois claims.
We're just not smart enough in Kansas to answer claims, so you don't have to file an answer. You get to, but we're a little faster than the people in Illinois. Once you see an application for hearing, you need to enter your appearance, and if you don't, 7 days later, if they're making a demand on what we call a 7-day demand letter for preliminary hearing, they can set it for hearing. So what you want to make sure of is if you get a pleading in or even a letter from an attorney that says, I think I might make a claim or I am making a claim, please call somebody. Call one of your defense attorneys and make sure that that is brought to our attention so we can make sure that attorney knows we're out there so they don't set a hearing on you quickly. You will get a hearing set on you real quick if they want medical or TTD and you've done nothing for it. I'm learning as we sit up here that Kansas also must be the happy medium. On the average weekly wage part, we're 26 weeks in Kansas, where you heard about the 13 and the 52. So that's the middle road. But real important in Kansas, there are no answers. But if you don't file an entry of appearance, which is the responsive pleading to what we call an application for hearing, the claims attorney doesn't have an obligation to contact anybody to set it for a hearing. Once he has a docketed case with the division, as long as there's a 7-day demand out there to the employer or its carrier, they can request a hearing.
And I did want to go ahead and just touch on this Porter decision that came out from the Southern District Court of Appeals. Ms. Porter was an 83-year-old worker with some prior problems, osteoporosis, prior broken bones, cataracts. She filed a claim for compensation, and the claim for compensation alleged that she slipped and fell on a wet floor. Well, at hearing, she testified that she had no memory of falling or what caused her to fall. The administrative law judge found that she had failed to meet her burden of proof that she sustained an accident arising out of and in the course of her employment because she could not identify the cause of the injury. Just because the injury occurred at work did not make it a compensable injury because she couldn't identify the cause. The commission agreed and affirmed the denial. The Court of Appeals also affirmed the decision, and they declined to apply the doctrine of res ipsa loquitur, which essentially states that you can infer from circumstantial evidence that there was negligence as a result of kind of what happened. Well, they declined to apply it to workers' compensation because it kind of directly conflicts with the requirements that an accident occur in the course of employment. So because she was not able to state what caused her to fall, she was unable to meet her burden of proof. What bolstered the case in looking at the decision, and it kind of ties into what we're going to talk about in a minute, is the fact that her statement was consistently that she could not recall what happened or how it happened, and there were multiple witnesses by deposition and live that came forward saying that she could not identify at the time of the injury what actually caused her to fall. And I think that those things bolstered the case in coming up with a denial. Notice. The notice requirement. In Missouri, you have 30 days to provide written notification of an accident, time, place, date of the occurrence, and on an occupational disease, 30 days within the diagnosis. Essentially, the employee can shift the burden a little bit if they can show that the employer was not prejudiced by failure to receive the notice, but that's a little bit harder to do in this day and age with the amount of investigation and how quickly we can provide medical treatment in this day and age. The Aramark case is an example of that. A custodian slipped and fell on black ice. She was out working. She didn't think that she was injured, so she didn't say anything. About 60 days went by. She went to her own doctor, scheduled surgery. A day or two before surgery, she reported it to the employer. At that point, that was not only outside the 30 days, but a little too late for the employer to do anything with respect to treatment or any sort of investigation. The ALJ denied the benefits on the grounds that she failed to provide proper notice, but the commission reversed, awarding TTD and PPD, and the Eastern District overturned the commission's award denying benefits. The employee was unable, or she didn't put forth any evidence that there was no prejudice. So she essentially failed on the prejudice evidence portion of her case, and that's kind of what did her in. But it was a denial on notice, and that's great news. I have had a case similar where there was a 90-day delay of the report of injury. At trial, the administrative law judge looked and actually relied on the medical causation evidence to deny the case and didn't even reach the notice defense. So as much as we would like to rely on it, whatever you can do to bolster the case otherwise also, I would recommend doing that as well.
On the Illinois side, the provision of the statute is Section 6C. And if no notice is given within 45 days, Michelle just said 30 days in Missouri, but it's 45 days in Illinois, it's a bar to compensation. So I think sometimes the notice defense gets a bad rap in Illinois, but you can win cases, absolutely, in Illinois with lack of notice. And it's a 45-day, they have to give it within 45 days. I was at the appellate court just within the last couple of weeks, and the first words out of the justices from the appellate court was about notice. And so I think it's an important defense. If there is a provision that says if inaccurate or deficient notice is given within 45 days, then the employer has to show they were unduly prejudiced. But the key is that you can have a good notice defense in Illinois. And if it's not given within 45 days, that can bar compensation.
Kansas also has a good notice defense, and it actually has been shortened to 20 days from the date of accident. It's the earliest of 20 days from the date of accident, 20 days from a repetitive trauma, subject to when the date of accident is, or 10 days if they haven't worked for you anymore. But the bigger issue in Kansas now, I believe, is an opportunity for employers to minimize who you can give notice to. The statute says if you're giving oral notice, the employer can designate an individual or a department that the employee has to give notice to. If they don't, they can give it to any supervisor or any manager. But if you've designated and you've put that in writing to your employees and they don't follow that and they don't meet the time deadlines, their case could be completely barred. So the rule of thumb I would have is if I was talking to a client, I would say, come up with who they're supposed to give notice to, put it in writing, and make them all sign off on a meeting or an orientation or whatever to confirm that they got that notice, and you have it in writing. So if they don't report it timely, you have not only the law on your side, but you have a piece of evidence to take to your preliminary hearing that will happen on the 8th day if you don't refer that case out quickly.
Employee statements. Employee statements can be given any number of ways. Reports of injury, formal notices, audio recordings, handwritings, pain diagrams. I recently saw a employee statement regarding an injury via text message. So we're going to be seeing a lot more of that. If you have employees that are out of the office and they have your cell phone number, there's your report or your statement via text message. The person who it was reported to was kind enough to transcribe that into an email so it appeared in a claim note, but that was the first time I'd seen that so far. Voicemail messages. So employee statements, you want to pay attention and make sure that we're keeping those somewhere because they can come in any form or fashion. And then in Missouri, to be able to use any statements that an employee gave regarding that injury, 287.215, attorney employees will provide certified notice of demand for statements, and those need to be provided within 30 days of that demand. Otherwise, you're precluded from using those statements at the time of hearing. So you can't hold on to them and surprise them at the end because you'll be foreclosed from doing that due to this section of the statute. I will go into it a little bit more, but 287.215 does not include video. We'll talk about surveillance here in a minute, but this is statements regarding the work injury and how you want to keep those, contain those, and be able to use them, preserve them later for hearing. Anything else about employee statements?
Well, I wrote down document, investigate. But technically, as you know, there's no formal discovery in Illinois. But there are a number of tools that you can use. With regard to the statement, there's a number of things you want to make sure that you obtain, including their name or maiden name, date of birth, social, wages, treatment, priors. If there's a dispute on an accident, as much information as you can get. Where did this happen? How did this happen? Who was there? And in terms of body parts, try to nail them down in terms of this was simply a left shoulder injury, correct? No other body parts, just your left shoulder, correct? So when the low back comes up later, you've got a statement from them saying, no, it was only my left shoulder. So those are the things that you want to focus on. I've seen some attorneys now doing webcams for videos, and there's audio. I think you mentioned that, Michelle, videos. The treatment too, when you're looking at that, I wouldn't focus just on medical doctors. I'd focus chiropractors, osteopaths. I mean, the whole range of healthcare providers I would look at. There's also, and you see this sometimes at Concentra, places like that, pain diagrams are important. You look at what the person, again, we'll go to that example with the left shoulder. They're just indicating the left shoulder. Later on, the back complaints, well, you've got the pain diagram from the time of the accident showing that. One additional thing, I don't want to go over my limit for Illinois here, but one additional thing is, obviously, one of the things in Illinois you always have to be concerned about is the Petrillo Doctrine, which prohibits ex parte conduct, or excuse me, not conduct, but contact with a treating doctor. And the Petrillo Doctrine is something that you always have to be concerned about. And one of the things when you first get the case you might want to do is to get an authorization from the claimant, which is broad enough to cover both written and oral communication with the treating doctor. So that would be one of my first order of business, that would be to get this authorization so you can contact that treating doctor. And of course, if I'm the claims attorney, well, the first thing I do is write you a letter saying I revoke any authorizations that you had previously had my client sign. But that would be, I would get that authorization out to the claimant right away.
I think this applies to all jurisdictions, but we all hear about the three-point contact. I think the recorded statement is hugely important. If we're going to take a recorded statement, let's take one. When we get into a deposition, the better the statement is, it's so much easier to corner the claimant in their deposition as to what is that issue, what are they asking for, and why are we here. Going to Dave's point about what's the body part involved, I'm sure everyone in the room can raise their hand and say, I thought this was a knee injury and you're talking about two shoulders and a nose. And that recorded statement was probably taken, hopefully, before the deposition. So amazing how, as time goes by, more things are a problem. So I think taking on that statement and taking it seriously, which I think everybody tries to do, is very important to how we're going to investigate the case. Michelle talked about a text. Sometimes we hear, well, I text my employer. Well, what did it say? Did it say you were sick? Did you say you were hurt? Did it say why you were hurt? So I think cornering these people, for better or worse, I mean, oftentimes my practice is I don't take a deposition unless we are in knee-deep litigation and we need it. If we're providing benefits, we move on that direction and we take the deposition at the end of all that if necessary. But we're not taking an unnecessary deposition. So if one of you all are asking us to take that deposition, we are using your recorded statement to help us minimize or maximize our defenses. One last thing, so I don't forget because I'll hear about it later. There are Kansas materials in here on case law. My name's on it, but I give Brandon Lawson all the credit for doing it. His name's on it too, and Brandon did a great job with those, and there are a lot of good cases in there, and when you're looking for some reading and it's not briefs like Judge Larson was talking about, feel free to read some up on case law in Kansas.
Sorry, Sarah, you're last, but I give Sarah Kraft the credit for the Missouri case law update that's in the book. Thank you. Photos, videos, surveillance, this kind of ties into what we were just talking about, but in addition to employee statements, accident site investigation can be extraordinarily helpful. And there's an Illinois case that kind of is instructional, I guess, or at least a leaping off point to discuss this.
Yeah, it's just, it's on page 58 of your booklet, but the Anderson case it simply involved a claimant who, at a commuter college, who slipped down some stairs. But the interesting thing, is, as Michelle points out about that, is there was video footage of the accident. which you see that more and more now with all the cameras and surveillance. A lot of times there's actual footage of the accident as it occurs. And so there was video footage of that, and then there was also photos that the claimant took. I also thought it was kind of interesting, there was a security guard that came in during the surveillance that was taking pictures too. Now hopefully he attended to the claimant who was on the ground at that point. I mean, talk about a good company guy. But there was both photos and surveillance in this particular case, so it becomes more and more important. In that case, they did award benefits because the photos did show a divot in one of the steps, and that's what the commission believed. But yeah, Michelle's right, it's becoming more and more important. Of course, the bigger picture in terms of the benefits of surveillance, obviously if it's good, surveillance can win the case for you. I mean, if it's really, really good. I've seen some surveillance where someone's walking out of Kmart with 2 plastic bags. I don't think that's going to do it. I mean, it's got to be a little bit more than that. Who knows what it could be? Paper towels. It could be 2 pounds in each bag. So it's got to be a little bit more than that. But it can show someone working outside the restrictions imposed by the treating doctor, and it can be helpful in cases. In fact, I've had cases where I've been in a docket, Illinois docket, and I've had an investigator about to testify, and they've been sitting over there on the bench, and I think that's helpful in negotiations sometimes, to have your surveillance people there, just to know that there's some surveillance out there. They may not know what it is, but we may put it on. So.
And when you want to use that surveillance strategically during the course of a claim, it may not be at the time of hearing. I had some surveillance of who we like to affectionately call Farmer John. He'd already had one shoulder surgery and was seeking another shoulder surgery and sent out surveillance, and we found him mowing his farm with one arm, the arm that he was requesting additional surgery for with a push mower, and bathing his pigs. And it was pretty compelling stuff when we're talking about another surgery. So needless to say, it was an admitted injury, so he did walk away with some money, but not a second surgery, and much less than he probably would have had we not caught Farmer John farming. So, what you do with good surveillance can have really a positive effect on the outcome of a case. Do you have any good stories, Dave?
Well, I do have a good story, and it was recent. We have a case, it's actually a Missouri case, and a woman was saying she hurt her knee slipping at work. This great employer, it's a grocery store, a lot of people come in. Well, they have just cameras all over the place. Well, amazing how they had a camera of this woman walking in. She said she hurt her knee on a Tuesday. Well, she walked in on a Monday with a knee brace on. So going to Michelle's point, had a big powwow with our client, and we decided to disclose this to the other side, and that case is officially gone. And that attorney wrote me a note that said, "I hate piddly cases." So I told her I like honest people.
In Missouri, the Western District addressed when surveillance needs to be disclosed. As we said earlier, surveillance video isn't necessarily considered a statement under 287-215, but the Western District, through Civil Rule 56 and Section 287-560, felt that it is a surveillance videotape that is discoverable through discovery processes, namely a subpoena ducis tecum for the production of that evidence prior to hearing, and that is discoverable. So the way that I have seen this is a subpoena ducis tecum issued for my adjuster and her surveillance information, being videos, reports, et cetera, generally what we anticipate to be a month or two before a final hearing. I don't know how commonly it's used. I've seen it a couple times. Is there anyone in this room that has been issued a subpoena ducis tecum for that sort of evidence? Mr. Ware? See, so it happens. I don't know that it's entirely common, but if this were to happen, by all means, they at least were kind enough to call me and tell me that they would be issuing a subpoena on my adjuster. But in case you get it, don't panic. Just call us and we'll go through it. Sometimes there's I guess, paranoid, or they just assume that we have surveillance on everyone. And I got on the phone and I said, I swear we don't have anything. We didn't follow this guy around. And that one went away too. So it does happen, but the Phelps case does say that it would be discoverable prior to hearing through the proper channels.
You get to sandbag people in Kansas. You get to show up at a hearing with some good stuff and see them kind of curl up and say, that wasn't me, and their attorney saying, why am I here? And can we take a recess? Can we take your last offer? So again, at least on our side of the state, and I think it's probably true on this side, you do a lot of work with a lot of the same attorneys. And the personalities of your opponent might dictate a little bit about when you want to bring this out. You know, if you're on this side and you're a claims attorney, you have a great relationship with Kim Parks, Kim might say, look, I can nail you now, or I can make it really bad later, but you know, this is a $200 case, it's a $2,000 case, but it's not a $50,000 case, and here's why. And depending on your relationship with people, you can say, now's the time or now's not the time, and sometimes it might be how nice some of the letters are that they send you. You know, every time you get a letter that says greetings, it never ends well, okay?
Witnesses. Get it in writing. I love a witness statement from a foreman. It's 2 sentences long, but it happened on the day of injury. You know, just a quick, this is what I saw. And 2-3 months later when the file comes in, or 6 months later when you're looking back through to find that gem of evidence that will really help your case, you realize how much value is in a timely statement, even if it is short. You know, a quick email or a statement in writing is fantastic. Verifying contact information for any witnesses that come forward. In this day and age, it feels like people move around a lot, and a cell phone or an email address is probably better than even a mailing address or a work phone number anymore. Being able to find that person when you really need them is helpful. Considering the source of your witnesses that come forward, you know, what is their relationship to the injured worker, or what information they may have, or their own credibility, just identifying who is coming forward and how that may help a case later on.
I would just jump on that part and say, you'll see on the slide it says supervisor or coworker. If it's a supervisor or manager, combine the company. So if they have information that hurts us, we need to know that. If they have information that helps us, we need to know that. A coworker's a fact witness. A manager can end your case.
Mm-hmm. Well, just in terms of Illinois, I would reiterate what Michelle said about contact information. That's pretty critical. People, if the case is 2 or 3 years old, they may have moved on. And I've had several instances where you're trying to track down witnesses. So that's a really good piece of advice. We did have a case, page 59, the Ott case, which goes to what Dave said about who the source is, the supervisor or the coworker. That was a warden who had his own parking spot at a correctional facility. I'm thinking something like Shawshank Redemption or something. But he trips going over the curb, and he says, you know, there's a defect there, and they bring out this. The employer brings out the assistant warden to go out there and measure it, and he says, no, there's nothing wrong there. That had to be a little awkward, but eventually the commission found in favor of the claimant, the warden, and awarded compensation. But it goes to the point made by Dave. So.
I would also add one other thought. Getting back to the recorded statement of the claimant, if there are witnesses, let's go find them. Let's talk to them if there's any question about the case. And again, what is their role in it? Are they, you know, do they go to lunch with Bobby every day, or do they have a problem with Bobby? You know, why are they a witness? And you know, there's amazing how many cases we deal with where there are no witnesses, even though people work 5 feet from each other. So it's worth asking the question in the recorded statement, and I believe worth following up with them if there's any question at all.
And then going back to that Porter case with the 83-year-old, you know, deciding what to do with that witness. You know, do you just need an interview? Do you need a recorded statement? Do you need to take that witness's deposition? Or do you bring them to hearing? And I think in that Porter case, they had 2 witnesses by deposition and 1 live witness. And strategically, what they decided to do with those witnesses probably tipped things in the defense's favor by how they used and what actual witness they decided to put on the stand live. And those are the decisions that we can all make together to put forward the best case possible. And this kind of goes forward to, claimant depositions. We have the recorded statement and timing of a claimant deposition. I prefer, like Dave said, to have as much information as I can possibly have before I sit down and talk to them, either to ask more pointed questions or to be able to uncover inconsistencies during that deposition. Sometimes you don't have that luxury and you need information. Sometimes you want to wait till they're finished treating so you can wrap everything up. So that's a decision that you would want to make together as a team.
With regard to Illinois, you're not allowed to take the deposition of the claimant, so that makes it a little bit more difficult.
Unless they also file in Missouri, and then you take the
This is
deposition
true.
immediately.
Right, and you've done that. But that's exactly right. There's no, some attorneys allow you to have an informal chat at one of the dockets or their office, so that's helpful. But there's other methods, as noted here, in terms of Facebook, the Industrial Commission website. The Illinois Workers' Compensation Commission website is iwcc.illinois.gov, and that's a pretty good website. You can do a name and birth inquiry. You can look if the person's had prior cases, prior settlements on that, and also lists the commission decisions as well as the appellate court decisions right on the website. So it's a pretty good website. It's a good investigative tool. In addition, Facebook is kind of hit or miss, but if they've got if the settings on Facebook are public, you can really get a lot of information on there. I've had several cases where it's public and the person is out doing a lot of things in water skiing and things like that. So that's something certainly to take a look at. And of course, the ISO claim search, investigating that and following up on that.
I also like the Missouri Department of Natural Resources. You can get hunting, fishing license information online, essentially turn around in a day, and it's free. So if you have your hunters, your fishermen, you can get a license history going back 10 years if you want it, so you can see patterns of what they hunt and when they hunt it, and you can get that back pretty quickly. I like that one. And then just standing here this morning, chit-chatting with some people, we have some savvy internet surfers that were stalking Pinterest and Match.com on a particular claimant for updates and activity. And I didn't think of that. And that's fantastic. There's a whole bevy of information out there if people are out there and they don't hide it.
Something funny. I was at a presentation the other day, and this is not mine, but someone offered it, and I just thought we had to use it today. They were talking about taking claimants' depositions. And the attorney said, well, here are the ground rules. I'm going to ask you lots of questions. You give me answers. You're under oath. Don't lie. If you need your attorney, ask your attorney for help. And then said, all your answers have to be oral. So he said, please state your name. And the witness said, oral. So I thought that was very important in what you get from a witness.
Oh, my gosh.
So remember, lead them. Get them where you need them to go. But much more importantly, in the Kansas side of things, Kansas does it a little bit differently. We're all trained, get your evidence, get it all together, take it to a hearing, let the judge decide. And in Kansas, that's all true except for your expert depositions are taken with 60 days roughly. The statute says 60 days, but there always seems to be small extensions. But you get your evidence from your experts in depositions 60 days after what we call the regular hearing. So uniquely, if you get testimony from your claimant at the regular hearing that might affect your case negatively, you have an opportunity to sit down or at least work your experts into how does this help you, how does this hurt you, but you might be able to work on something in those 60 days that if we were in Missouri, and I can't speak for Illinois, that you can't recover from. So the timing of the expert deposition in Kansas, which our depositions are 60 days after the regular hearing, we have to have those in. The claimant is 30 days. So you actually get to be the very end to kind of work it back to see if you can recover from something that's hurting your case.
Okay.
Leading right into expert depositions, experts are something we spend a lot of our day talking about, discussing, contemplating, And choosing an effective expert can sometimes be a very difficult decision. You know, first and foremost is always what's the pressing issue? Is it a treatment issue? Is it a causation opinion issue? Is it a return to work issue? Is it a cost of a report or treatment issue? And sometimes those considerations can move you one direction or the other. You always go to your trusted advisors and your excellent care providers, but those are considerations that you have to take into account when you're choosing someone.
Well, in Illinois, it's called a Section 12 evaluation. And I guess the first thing I'd say is you don't need them on every single case, but they can be very effective. They can be a good discovery tool. The evaluating physician can get a lot of information down, can take prior medical history, prior injuries, and from that IME, that Section 12 evaluation, you might be able to discover further information, send out further authorizations to defend the case. So it is an important tool, but whether or not you need it in every single case, I think I'd consult with your trusted advisor, as Michelle says. With regard to the Section 12 evaluation, just a couple more things I just wanted to mention. Always send the mileage check with the appointment letter, otherwise they don't have to come. So you need to make sure that the mileage check is sent when we schedule that evaluation. I wanted to say a couple things on medical records in Illinois. Section 8A of the Act says we're entitled to receive the medical records for these injuries, but if you send out a letter simply citing the statute, there's probably a good chance you're not going to get the records. There is a provision in the rules talking about the claimant has to sign executed authorizations, but again, I've had motions before arbitrators who say they don't have to necessarily enforce that provision, as there's no discovery in Illinois workers' compensation. So it can set up a roadblock. We have subpoenas that we can use, which are pre-signed by the commission, but those, with regard to the subpoenas, I would make sure that I would carbon copy the other attorney and get their agreement on that. We have a problem sometimes in Southern Illinois and Missouri. We'll have a case, we're trying to get the records, and the arbitrator may say, well, subpoena the records. Well, the medical care provider is on the other side of the river. So do we send a subpoena to a Missouri physician? That could, potentially that's an abusive process. So it puts us in a difficult situation where we may have pertinent, relevant medical records that would be difficult to get. So those things are factors to take into account with regard to experts in Illinois. With regard to medical depositions, I think I would say that those are usually by agreement. If there's no agreement, then you have to get a dedimus before the Industrial Commission, or Workers' Compensation Commission, excuse me.
Just to take care of a couple of housekeeping matters, please repeat the address for the hunting and fishing licenses. I use the Missouri Department of Natural Resources website. You have to dig around a little bit, but I think you can just search in the search toolbar within the website and say open and public documents or a license history or permit history, something like that, and you will eventually get it to pop up, and it's a form screen that you print out and hit submit, and like I said, magically the stuff comes back like the next day. It's pretty cool. And there was another question about the Illinois Commission website.
Yeah, and that's iwcc.illinois.gov. So.
And let me add one thing. Yeah. And the Kansas experts, one other really important point, all cases are required to go to what we call a pre-hearing settlement conference before a regular hearing. The judge has the opportunity to clear the case, kick you out if they don't think that the case is ready to move forward, but more likely they clear the case for trial, or they have the right to order what we call an IME. That IME is at our expense, the defense side. So oftentimes you'll see the same type of doctors ordered by the court for the independent medical evaluation. That doctor is basically, if we're talking about a nature and extent case, the answer to what your award will be. The judges follow those doctors. So there's some gamesmanship in who you pick from the treatment side. To me, there's no gamesmanship. We're trying to find the best doctor to get these people who are injured feeling better and back to work if possible. But keep in mind, when the other attorney goes out and spends $400 on an IME when everyone else is spending 3 or 4 times that, possibly, or more. They're doing it for a purpose to get to the court-ordered IME that we have to pay for. So likely in a litigated case in Kansas, you'll have 3 at least, but 1 court-ordered IME, which will be the driving force in the case. So that doctor is very important that most of the judges want the attorneys to work out who it will be. You want to make sure that they follow the AMA Guides 4th edition in Kansas, and if they're not familiar with that, you want to make sure you find a different doctor.
To wrap all of this up, just an overall assessment when it comes to investigations, statements, depositions, experts. A lot of considerations go into that when making your decision, and additional considerations would be your venue, your potential mediation judge, your potential trial judge. All of those things could impact your choice, particularly when you hear, oh, that judge really doesn't like that doctor. And you make mental note of that, and you say, this is probably going to be my mediation judge. I probably shouldn't send him there because this is going to be a toss-out opinion, and it's going to be a hard sell when it comes time to sit down and try to resolve that case. Do you have any other?
I think that's spot on, Michelle, and you're right. There's no substituting experience, and as you point out, if you know this judge and know this attorney, and in consultation, you make the decision whether or not it's prudent at that point to go forward with the hearing or maybe settle the case.
And it goes without saying that it's all well and good, and we have fantastic evidence, but we need to make sure that it's admissible. Do whatever you need to do, follow the protocol, follow the statute, make sure that it's served when it's necessary to be served and shared when it needs to be shared, so it's not excluded at the time of hearing. And then, as far as strategic planning goes, you work as a team and decide when you're going to use that evidence, but securing admissibility is always in the back of our minds for sure, and the most important thing when you're going to spend the money to get the evidence.
Go ahead, Dave.
No, please.
Just to go back to what I said originally about the 15 days, that's the thing in Illinois, is it can come up so quickly that to get an IME, if you get a 19B petition and you get it to your attorney so that we can react quickly, perhaps get an IME, but it can come up very quickly, so you need to take that into account.
Right.
I was just going to add one last thing. When you're talking about the judges in Kansas, the pre-hearing settlement conference process, that judge is your trial judge. You don't get a change. So you can use that as an opportunity not only to figure out what they're going to order or clear the case, but you can educate the judge on what you're going to argue at the hearing, and certainly you can use it to find out how strong the claims attorney is going to argue their points. So I don't use a pretrial as, hey, get us cleared, order an IME. I also use it as an opportunity to educate the judge on what we're going to argue about if it gets that far.
And so just pretrials are also useful in Illinois too. I mean, we do use those a lot. Some arbitrators, depending on what part of the state you're in, some almost require them, so they can narrow the issues and lead to a maybe expedited resolution of the case. So they certainly can be effective.
We got another question here. Can you speak to your collective experience with fraud cases?
Yeah, that we don't like them.
Yeah, we don't. Dave's not a fan of liars. I've had, that's our reminder.
We're out of time. I think that
We're
means-
close. I've had some cases that have had pretty good. Farmer John was one that we decided, at least contemplated maybe turning that over to a fraud unit. The Missouri Attorney General's fraud unit and investigation department is burdened. I mean, they're really overwhelmed. We wouldn't necessarily, discourage that, but proceed in the workers' compensation claim as you normally would and submit that evidence and keep your fingers crossed that you would potentially see something come back later. But when I've worked with that office, as kind and responsive as they are, the one gal did tell me, things are just stacked up in the corner. So, I mean, I think that if they get really compelling, fantastic evidence, it's well worth your while to go ahead and submit it. But I know that they are overworked. At least that's been the response that I've generally gotten.
There is a fraud unit in Illinois now. It's up and running, and it's the last 5 to 7 years, the number of investigations has increased. And sometimes it's incredible how stupid people can be on some of these things. The things that they do, with getting money at the same time that they're working full time, at a job. But I guess the short version is yes, there is a fraud unit in Illinois, and yes, they are continuing to investigate more and more cases.
And I would say in Kansas, the same thing. I would flip it, though. I would say when they're looking at the employer and insurer, they latch on pretty good because we're all looking at the individual saying, hey, this is a fraudulent claim if that were to come up. But if they feel like an employer is wrongfully abusing the process, they definitely let you hear about it, and try to assert some kind of penalty on you. But so if you get that letter, which I don't think anyone in this room would ever get, but if you get that letter, it's important to pay attention to it.
And I'm sure that there's a flashing light somewhere telling us that our time is coming to a close. So I did want to bring your attention to a decision that was issued on April 15th by the Supreme Court of Missouri. There is an insert in the back of your book addressing this Temple-Meyer versus W&M Welding Incorporated. It's essentially a retaliation employment case that is grounded in Section 287780 regarding discrimination. Temple-Meyer was released following foot surgery to return to work with restrictions, was working those light duty restrictions, but apparently not to his employer's satisfaction. I guess he was sitting on his bum while he should have been washing a rail. They got into a heated argument and he was terminated on the spot. He filed a retaliatory discharge claim, and the jury instruction originally was whether the workers' compensation claim was the exclusive factor in the employer's decision to terminate him. Well, it was appealed, and the jury instruction was the main issue, and the new jury instruction was whether the workers' compensation claim was a contributing factor in the employer's decision to terminate. So we went from, is the workers' compensation claim the only reason for the employment action, to a reason. That's hugely upsetting. It's probably going to be problematic. How we think that we are going to see this come up in workers' compensation claims is how Dave has already seen it. A savvy plaintiff's attorney sent him a letter the other day, and it said essentially, my guy is released to return to work, but you know that he has a pending workers' compensation claim. He's slower than he used to be because he had surgery, and he's been passed over for a raise and promotion. I just kindly remind you of the new Temple-Meyer decision. Thank you very much. Have a nice day. So when you get that letter, because I think we might see a few of those, we talked about this before, immediately notify the employer and consult your employment defense attorney regarding any allegations of that sort, because I think this case, we're going to see it. They're going to use it probably in an attempt to leverage some sort of action from the workers' compensation perspective.
That's exactly right. The ink wasn't even dry on the decision, and I got this fax from the claims attorney, and it said what Michelle said, and it said the person has rights. You better, be careful here. So they're well aware of this decision. It's a big deal in Missouri. So.
It wasn't a unanimous decision. Judge Zell Fisher did write a dissent, citing stare decisis and years of case law that held the other way, but clearly this is now the law of the land.
We have employment attorneys in our firm. Pat told you how we're expanding, and we've been working for years. So if you get that letter, we have attorneys who can address that for you, but let's hope you never get that letter.
Are there any other questions? I don't have any new texts.
We're good.
Great. All right, we'll take another 10-minute break and be back here at 3. And two of our superheroes from the firm, James Kennedy and Mike Banahan, will be presenting.